For today's story, we continue to follow up with New York State, who continues not to like guns very much. As you guys will remember, New York State lost in the Supreme Court on the whole right to bear arms thing. It took a while, but we did finally get there. NYSRPA versus Bruin. Well, New York tried to respond to this by saying, okay, we'll give people a concealed carry permit after they go through, this incredibly cumbersome, lengthy, expensive process. But we're also going to ban them from carrying in sensitive places. Where are sensitive places? Well, basically all of New York, or at least all of Manhattan, by the way it's defined. And so, yeah, the New York has been trying to circumvent this thing, and recently has been having some tough times, at least in part, as New York law has now been struck down with respect to people carrying in churches. Let's go ahead and read a little bit about this. All right, so this comes courtesy of a decision by the Northern District of New York Federal Court. So that's not Manhattan. Manhattan's the Southern District, but still Northern District. And so applies to Manhattan as well. This comes from the case of Hardaway versus Negrell, one of many, 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 many cases currently working their way through various stages of the New York appellate system on this issue. So let's read a little bit from this decision. 8 days after the Supreme Court struck down New York's unconstitutional proper cause requirement, which said you can only get a right to bear if you have a special reason, which kind of defies the principles of the Second Amendment, which by its nature apply to everybody. So, that was a problem. The state responded with even more restrictive legislation, arguably at least, banning all concealed carry license holders from vast swaths of the state. So yeah, they said, okay, we'll make it possible for you to get a license, but we'll basically make it impossible for you to use it anywhere. The lawsuit and motion in this case that was just decided focused solely on one aspect of that legislation, namely the thing that made it illegal to carry in any place of worship or any religious observation. Ample Supreme Court precedent addressing individual right to keep and bear arms, from Heller and McDonald into its 2022 decision in Bruin, dictates that New York's place of worship restriction is equally unconstitutional. Now, just for the sake of clarity, by the way, this doesn't necessarily speak to a church making a decision on its own to exclude firearms. The law just said that you can't carry, period, in all places of worship, whether they wanted it or not. Whether a church can ban it by their own choice is not the issue here. The issue is, well, if the church doesn't have a problem with it, what then? So, yeah. In Bruin, the court made the Second Amendment test crystal clear. Regulation in this area is permissible only if the government demonstrates that a regulation is consistent with the nation's historical tradition of sufficiently analogous regulation. As set forth below, New York fails the test. The state exclusion is, instead, inconsistent with the nation's historical tradition, impermissibly infringing on the right to keep and bear arms in the public for self-defense. In the case that was decided by this court, the Reverend Dr. Jimmy Hardaway and Bishop Larry Boyd filed a lawsuit and are joined as institutional plaintiffs, Firearms Policy Coalition, and the Second Amendment Foundation. The Second Amendment Foundation is someone that I'm well familiar of. I'm a lifetime member of them as well. And they do great work in the litigation domain in Second Amendment land, so I really like them. Hardaway and Boyd, leaders of their respective churches, wish to exercise fundamental individual rights to bear arms in public for self-defense by carrying concealed firearms on church property, in the case of confrontation to both themselves and congregants. They allege that as leaders of their churches, they would be authorized to carry on church premises to keep the peace, and would do so, but for the state of New York's enforcement of unconstitutional laws, regulations, policies, practice, and customs at issue. In particular, they seek to prevent the enforcement of New York's law that makes it a felony to carry firearms at all places of worship and all religious observations. The state had argued that the place of worship exclusion complied with Bruin. The state cites to 1870 to 1890 enactment by 4 states. That's way too late, by the way, for the Second Amendment analysis. And territories that contain place of worship firearms restrictions. No. At the outset, as the Supreme Court has made clear, Individuals have the right to carry handguns in public for self-defense. New York's exclusion is valid only if the state affirmatively proves the restriction is part of the nation's historical tradition of firearm regulation. The test is rigorous because the Second Amendment is the very product of interest balancing tests already conducted by the people, which elevates it above other interests, the right of law-abiding citizens to carry in self-defense. That's the thing. The Second Amendment, like all provisions in the Constitution, already did the cost-benefit analysis. That's the point. It already did this. We don't have to redo it. It's been done. It's been fixed. If you want to change it, amend it. The cost-benefit analysis has been done and fixed. So you can't redo it. It's been done. New York's restrictions find no analogy in any recognized sensitive place. In Bruin, the court noted, although the historical record yields relatively few 18th and 19th century sensitive places, which by that point is way too late when talking about the Second Amendment, which was enacted in 1791, but I digress, that prohibited carry in legislative assemblies, polling places, and courthouses. They're aware of no disputes regarding the lawfulness of such prohibitions, and courts can use analogy to historical regulations of sensitive places to determine modern regulations prohibiting the carry of firearms and new and analogous sensitive places that are constitutionally permissible. In particular, places of worship or religious observation are unsecured, spiritual places that members of the public frequent, as they often daily as part of their day-to-day life. Yeah, different churches are open different days. And certainly some churches and some religions, people go to them very, very frequently indeed. In contrast, legislative assemblies, polling places, and courthouses are locations generally visited very sporadically. Yeah, where a bad-intentioned armed person could disrupt a key function of democracy. Legislative assemblies and courthouses are further typically secured, which also is a nice point of note, right? We do have a mechanism, however imperfect it might be, but we do have a mechanism to screen people for firearms to try to ensure that no one has firearms and we also have armed police right there. So those do prevent a different environment. Yeah. The state's argument that places of worship are analogous because exclusion supposedly also minimizes the chance of violence between those with opposing views is underdeveloped, and in any case belies the non-confrontational purpose drawing people to houses of worship in the first place. Yeah. So houses of worship can exclude, but most of the time they don't, because their whole point is to get new people to join. So yeah. The argument would apply nearly everywhere in public. Places of worship and religious observation exclusion finds no analogy in Bruin-sensitive places, not so much. As in Bruin, where apart from the handful of late 19th century jurisdictions, the historical record compiled by the state does not demonstrate a tradition of broadly prohibiting the public carry of commonly used firearms for self-defense, the state does not demonstrate a tradition of broadly prohibiting the public carry of commonly used firearms for self-defense at all places of worship or all religious observation across the state. Nevertheless, the state relies on a few laws from the late 1800s to insist a relevant tradition exists. Bruin anticipates this argument, rejecting the relevance of an outer analogous law and state court decisions. The court stated that it would not give disproportionate weight to a single state statute and a pair of state court decisions. As in Heller, we will not stake our interpretation of the Second Amendment upon a single law in effect in a single state that contradicts the overwhelming weight of other evidence regarding the right to keep and bear arms. So yeah, you might be able to find a few disparate examples, but that is not how we do Second Amendment interpretation. The enactments at question are of unknown duration, and the state has not met its burden to show endurance over time. As a result, the court is left with a handful of seemingly spasmodic enactments involving a small minority of jurisdictions covering a small minority of the publication, and they were passed nearly a century after the Second Amendment's ratification. It's kind of a big deal. The Second Amendment, it reflects the right to keep and bear arms as it was understood in 1791. Legislation a century later probably not that helpful to understanding what was understood in 1791. Yeah. These outlier enactments also contrast with colonial era enactments that in fact mandated carry at such places of worship. Indeed, South Carolina and had such a law, and I think technically still has it on the books last time I checked. But yeah, these enactments are far too remote, far too anachronistic, and very much outliers, insufficient then in the search for the American tradition. Thus, that brings us to the end of this trial level decision that is talking about New York state laws. New York state laws have been challenged many places, and many decisions have already found the New York state law to be extremely wanting because it tries to declare all the places to be sensitive. So many places that in the Isle of Manhattan, for example, it'd be basically impossible to carry anywhere, which I think is kind of the point. But the courts are looking at this one at a time and basically saying no. The Supreme Court has laid out the test, historical analog. 1791 is your date in question because that's when the right was established. And so as you move further and further from that date, you're going to have problems. Further, either direction, by the way. So yeah, the more further you go, the less relevant. So especially as it relates to the American experience, right? So yeah. So the courts have struck this down, not the first time, not the last time, I'm sure. At least for a moment, without bringing this to the end of the discussion of the story.